Good evening, everybody, and welcome to Supreme Court Observer's live daily up. Good evening, everybody, and welcome to Supreme Court Observer's live daily updates. I'm R. Sai Spandana. I'm an associate editor at Supreme Court Observer. Today, our main story concerns the plea for marriage equality. Today was day 2 of the hearings before the Constitution Bench led by Chief Justice D.Y. Chandrachud. To briefly recap what happened yesterday, the morning session of the arguments, the bench essentially heard the preliminary arguments by both the petitioners of the case as well as the union government represented by Solicitor General Tushar Mehta. And the bench came to the conclusion that the case must be dealt with in an incremental manner. So for now, this case would be restricted to the contours of the Special Marriage Act of 1954. In the afternoon, Senior Advocate Mukul Rohatgi began arguments for the petitioners. He stated that the right to marry was a fundamental right and the state was duty bound to recognize this right for LGBTQIA plus couples. In today's hearing, Senior Advocate Mukul Rohatgi continued his petitions for continued his arguments for the petitioners. He firstly rebutted the Solicitor General's argument that the case could not be heard without involving the states in the current petition because marriage fell under entry 5 of the concurrent list of the Constitution, and therefore without getting the states' involvement in the case, the petition was not maintainable. Advocate Mukul Rohatgi responded to this by stating that the act under question in this current matter was the Special Marriage Act, which was a central government legislation. Therefore, the involvement of the states was not particularly necessary in order to decide the maintainability of the current plea. Then he went on to argue that in the present case, what the petitioners seek is a declaration by the Supreme Court not only to recognize queer LGBTQIA plus marriages, but to also provide them with the necessary day-to-day rights that ensure that their everyday lives are not at a disparity compared to other couples, namely the heterosexual couples. He said that one of the first steps in this regard would be to use gender-neutral language in public spaces and also in the legislation concerned, that is the Special Marriage Act. Wherever there is man or woman, replace those with words like person or parties, etc. And he stated that through case laws, the court had established that everyone was entitled to the right to privacy by the judgment in Puttaswamy. Secondly, by the judgment in Navtej Singh Johar in 2018, homosexuality was decriminalized from the IPC. And Mr. Rohatgi stated that though these were important and significant steps in guaranteeing same-sex couples and other queer couples rights and important steps in reducing discrimination faced by the LGBTQIA plus community, this was simply not enough. The next step had to be the legal recognition of their marriage so that other benefits such as adoption, insurance, and other day-to-day stuff could be granted to them at par with heterosexual couples. Further, he also cited the Supreme Court's judgment in the case of Shafeen Jahan in 2018, in which the court declared that every person had the right to choose who they want to marry, and nobody, not even the state, could impose restrictions on this right to choose. Further, when it comes to LGBTQIA plus persons' right to privacy, it is not enough that we say that your relationship is not criminal anymore and leave it at that. Something more needs to be done. Rights need to be a lot more substantive than just leaving them alone at decriminalization. Further, Mr. Rohatgi also drew the bench's attention to the fact that homosexuality and queer relationships were actually recognized in the cultural history of India for thousands of years. And the concept of criminalizing homosexuality and other queer relationships only came with the British era. And he cited that ancient Indian temples had carvings and murals that depicted queer relationships, and that was proof of the fact that it has always existed in our culture going forward. And so he pled that the declaration that the Supreme Court makes must not only recognize same-sex and other queer marriages, but must also grant them other rights, substantive rights at par with heterosexual couples. And in this way, the court would lead the dialogue in changing the societal views of queer marriages and relationships. With this, Senior Advocate Mukul Rohatgi concluded his arguments, and Senior Advocate Abhishek Manu Singhvi commenced his arguments for the petitioners. Mr. Singhvi stated that primarily people want to get married for 5 major reasons. First, marriage provides them, the couple, with a sense of social acceptance. Second, they also receive a sense of safety, not just of their relationship, but of their relationship with other members of society as well. Thirdly, there is a certain level of public security offered with marriage. Fourthly, marriage is a gateway for many other rights such as adoption, maintenance, insurance, rent, and pensions after retirement, right to bodily and many other rights are dependent on whether a person is married or not. So by recognizing marriage, we also gave way to a lot of other rights and say that queer couples are eligible to those rights. For instance, if you look at bank insurances, the only requirement there is for a nominee is for them to be the spouse of the person nominating. Therefore, by recognizing marriage, a lot of those kind of issues can be solved. And lastly, marriage provides a sense of fulfillment for the couples involved and gives them a sense of familial security. And Mr. Singhvi stated that LGBTQIA plus couples should not be deprived of this sense of security, social acceptance that marriage provides them. And he states that by denying LGBTQIA couples these rights, that is the right to marry, is a breach of Articles 14, 19 and 21 of the Constitution of India. Article 14 provides equality and equal protection of the law for all the citizens of the country. And Mr. Singhvi states that by excluding the LGBTQIA plus community from the Special Marriage Act provisions, their right to equality is breached. And he further states that no custom, no culture or no tradition can be so strong that it supersedes constitutional values, and the constitutional values demand that all citizens be treated equally. Going on to the argument of Article 19, Mr. Singhvi states that the right to expression involves in it the right to expression of sex and sexual orientation. Therefore, by denying marriage rights of same-sex and other queer couples under the Special Marriage Act, their right to express their sexual orientation and sexual identity is breached. In this regard, he says that there is a correlationship between Article 14 and Article 19 in the following way. So the state is essentially not recognizing or excluding LGBTQIA plus couples from the Special Marriage Act by denying them the right to marry right now. This denial in turn is denying them their right to express their sexual orientation. Therefore, there is a parallel created here. Next, going on to the argument of Article 21, which guarantees to all citizens the right to life and personal liberty. This right has within it an implicit right to dignity. And by not recognizing LGBTQIA plus marriages, Mr. Singhvi argues that the state is essentially telling them that you are not equal to other heterosexual couples, and you are not at the same par, not at par with them. You are lesser than them. And this was unacceptable. He further states that over the years, the Supreme Court's jurisdiction and the evolution of society and case laws from around the world have increasingly recognized atypical relationships, that is, relationships that defy the conventional norm of biologically male man as the husband and a biologically female woman as the wife. And the Supreme Court of India has also recognized this right in decisions such as Deepika Hariharan in 2022. Therefore, these relationships must be recognized going forward, and the marriage rights of LGBTQIA plus couples must be recognized. And he also drew the bench's attention to the fact that this sort of exclusion that exists of LGBTQIA plus couples is not based on who they are inherently or what they have, but rather based on ascriptive characteristics. In other words, this means that these are characteristics that the society and the majority of the society, that is heterosexual people, have ascribed to them. And this cannot be a ground for excluding them from the marriage law of the country, that is under the Special Marriage Act. Mr. Singhvi will continue his arguments for the petitioners tomorrow, and the bench will also hear other petitioners of the case tomorrow, that is the 20th of April. Stay tuned to our social media pages, our website. Do follow us on Twitter for live tweets and updates of ongoing hearings tomorrow. And we will see you again in tomorrow's live. Thank you.